Okay, so today we will be understanding the concept of basics of the Indian Evidence Act 1872. So first we'll be understanding the relationship between the procedural law and the substantive law, what kind of relationship they have with the Evidence Act. So when we talk about procedural law or substantive law, let's basically understand what these two terms mean. So when we talk about law, it is of two kinds. First is substantive law, and second being procedural law. So what is the basic difference between substantive law and procedural law? Firstly, that when we talk about substantive law, it is something which tells the rights and the duties of the parties. So whatever are the rights and duties of the parties that are defined in your substantive law. Like for example, Indian Contract Act, then Indian Penal Code, then the Indian Property Act. So all these are the laws that basically define your substantive law. They basically are your substantive law because in these particular acts, the rights and the duties of the individual or the parties are defined. Like for example, talking about the Indian Penal Code, under section 378, which is theft, we all know that the punishment for the theft is 3 years. But what is the procedure for the same will be defined in, like, we are claiming this thing that what is basically substantive law, that section 378 defines your theft. What are the essential ingredients of theft? That it should be taken out without the consent of the person, out of the possession of the person. It should be a movable property. All these, the essential ingredients are defined in it. At the same point of time, the punishment is defined in it that it will be 3 years. But in order to make a person liable for the punishment of theft, it is for a period of 3 years. It is essential that one must know the procedure for the same. And all this procedure is defined in the procedural law. That is, that you have to approach the court, the parties have to go, what all formalities they have to fulfill, what all evidences have to be produced by the plaintiff side, the victim side, or what all evidences have been produced by the victim, the defendant side, or the accused side. So all these things will be written over here in the procedural law. So procedural law basically tells you the procedure for the litigation. For example, basically example are CRPC and CPC. So these are the example of procedural law because they tell us the procedure that in case of some civil wrong, you can approach the court, or what all procedure need to be followed is defined in your civil procedure code in CPC. And if a crime is committed, or maybe some offense is committed under Indian Penal Code, so in what court or what all procedures will be required are defined in your CRPC. Now moving back to Indian Evidence Act. Now Indian Evidence Act is more of a procedural form, but at the same point of time, it also consists of certain sections which are substantive in nature. So in this particular area, what we basically define is that Indian Evidence Act is more or less, it is more of a procedural law. It contains procedures more rather than being substantive law, but still it contains certain areas that are also substantive law. So what are these areas that are there which are called as substantive law in Indian Evidence Act? The example basically is your section. It's basically section 115. All right. So it's section 115. which basically talks about the rule of estoppel or the doctrine of estoppel. Now, what does doctrine of estoppel mean, or what does rule of estoppel mean? Let's understand that. Section 115 of Indian Evidence Act talks about your rule of estoppel. Now, what does rule of estoppel means? That it basically prevents a person to rebut what has been represented by him. Now, what does this mean? That let's suppose that today I am saying this thing, that my name is Aditi, right? And tomorrow I am denying the same thing. I'm saying, no, my name is not Aditi, my name is Anamika. So this is something which I am basically contradicting my own words that I said the day before or yesterday. So rule of estoppel acts as a barrier for a person to deny his own fact, to deny his own statement. The basic purpose is to basically prevent a person to rebut. Rebut means to contradict or अगर मैं हिंदी में समझाऊं तो इसका मतलब क्या होता है कि वापस से एक चीज को बोल देना या उसको विपरीत कर देना. ठीक है, तो like to prevent a person to rebut. Rebut means that you cannot contradict or you cannot deny the things that you are saying. So what has been represented by a person, you cannot deny those things. So this is an important element of rule of estoppel. Now let's take an example to understand this thing. For example, that there are two persons A and B, and there is a piece of land. Now let's suppose that A wrongfully says this thing, that this particular X land belongs to me. So in that particular case, what will happen? And the next day, he basically tells B that you must buy this land from me, and or he compels that B that please take my land or all these things. So in that particular case, let's suppose that B buys it. So in that particular case, now A says, now currently at the initial point of time, A did not had the possession or the title of this particular land X. He wrongfully represented that he was the owner of this particular land. Now when B has purchased this land and now he has done the payment to A, B is claiming the money. So in that particular case, A, now let's suppose A is saying that I do not have the possession of this particular land. I do not have the title to this particular land. I cannot sell this land to you. And he has taken the money from B. So in that particular case, here the rule of estoppel lies, that as initially it was claimed by A that he is the owner, or he has the title and the possession of this particular land, now he cannot deny this thing. He cannot take his words back, saying that I don't have the possession to the land, so I cannot give this land to you. So here comes the rule of estoppel into existence, that as A has already claimed this thing, that he is the owner of the land or he has the title and possession of the land, he cannot deny this fact, or he cannot say that no, I am not the owner of this particular land. So this is given under section 115 of the Indian Evidence Act. At the same point of time, there is a case also. The name of the case is Ramjas versus Surendranath, AIR, 1980. What was said in this particular case was, it was said by Justice Hari Swaroop that the law of evidence basically it does not affect the substantial right, but it acts as a facilitator and in the course of the justice. So it basically acts like it in no way affects the substantial right of an individual or the parties, but it merely acts as a facilitator in the course of justice. At the same point of time, what basically is the basic idea of evidence is that it wants to guide the court so that there is a smooth proceeding that is going on. See, basically, if two parties are approaching the court, obviously, if I want that the case should be in my favor, I will have to present the evidences in front of the court, be it civil case or be it criminal case. I would have to present the evidences in front of the court in order to prove this thing, in order to show this thing that yes, this particular thing happened and that is why this particular case is in my favor and I should get the justice and the other person should not get the justice. So that is why the rule of the law of evidence plays a very, very important role in order to guide the court as to how they must act. Because if a particular evidence is in favor of one party, then in that particular case, that particular the court will examine those evidences that are presented by them, and whatever, after analyzing everything, they will come to a conclusion that okay, this particular after looking at all the evidences, we come to a conclusion that the case is in favor of this particular party, right? At the same point of time, the law of evidence is basically a procedural law which helps to prove a fact in a court of law. So we'll be understanding what basically this term fact or proof basically means. So basically, just giving a slight insight into what this word fact means. See, facts can be taken into two particular considerations or two parts. So basically, fact means two things. One considers is any particular thing, anything, or maybe any state of thing, or it could be a relation of things. And second is the mental condition of which one is conscious of. Now, what does this mean? Basically, according to Bentham, there were two classifications of this particular term fact. First was your physical fact, and the second was your psychological fact. So when we talk about physical fact and psychological fact, see, physical facts are those facts which can be touched, which can be felt, which can be seen. Like, for example, if a particular thing is placed at a particular place at a particular point of time, so this will be considered as a physical fact. That particular thing can be seen, that particular thing can be felt, it can be perceived by our senses. So whatever is being perceived by our five senses, it will be considered as a physical fact, right? And this particular physical fact can be either proved by some direct evidence or maybe by some circumstantial evidences. Moving on to the psychological fact. Psychological facts are something which cannot be seen. You cannot see them. You can only feel them. So in that particular case, like the example that I can give of psychological fact are your intention, your knowledge, your good faith, all these come under the category of psychological fact. Also under psychological fact, like for example, a person's reputation. We all know what reputation means. Reputation means the image that the people of the society have created of a person and not what he himself perceives himself to be. So reputation means that it's not your perception about yourself, but rather reputation means how society look at you, or what idea or whatever opinion the society has formed for you. That is your reputation. That reputation obviously cannot be seen, it cannot be touched, but it can only be sensed or analyzed. After looking at the people that okay, this particular person has created this image for me in his mind. So it is a mental condition of which a person is conscious of. So this is the basic difference between the physical fact and the psychological fact. Now let's understand this thing by an example that let's suppose A is a person and B is a person. Now A has shot B. So in that particular case, what will be the physical fact? Now let's suppose when A was shooting B, X was the person who was present at that particular point of time, and he basically saw A shooting B. So in that particular case, this will become a physical fact. That is, it is a direct evidence that is present in front of us that X has witnessed. X is an eyewitness and he has witnessed this thing. Moving on to, if we are moving on to the psychological fact, then with what intention or with what knowledge did A shot B? That is your psychological fact, because it cannot be merely analyzed by looking at the person. This is a true fact that an intention of a person is never ever punishable, because obviously we cannot analyze what a person is thinking or what is going on in the mind of a person. Intention can only and only be analyzed by the execution of an overt act or by the external manifestation. Whatever external act you are doing, by that only the person can analyze that what the intention you can perceive the intention of that person by his external acts only, right? So that will your intention, your knowledge, your good faith, everything, these come into the category of your psychological facts. So this is about your Indian Evidence Act, the general, that what is the relationship with the substantive law or with the procedural law, and secondly, that what basically is the definition of this term fact. Moving on to the next part. Now see, Indian Evidence Act is basically divided into three parts, part 1, part 2 and part 3. So part 1 talks about your relevancy of facts. And this relevancy of facts is further subdivided into two parts, that is preliminary, which is from section 1 to 4, and rest is your section 5 to 55, that is relevancy of the facts. That is, what are the facts that are relevant in a particular case. This is from section 5 to 55. After that, the second part, that is on proof. And the third part is production and effect of evidence. Now, if we talk about the Indian Evidence Act, it actually finally it got enforced in 1872, 1st September 1872, it got enforced. And on 15th March 1872, it finally got the Governor General's assent. So this is how it basically came into existence. So there were a number of attempts that were being made in order to make the Indian Evidence Act, that we'll be studying in the history of the Indian Evidence Act slowly and gradually. At the same point of time, Indian Evidence Act has 11 chapters, and the 11th chapter is the shortest one because it only consists of section 167. And total sections that are there in Indian Evidence Act are 167. So the shortest chapter basically is your chapter 11, and the longest one is your chapter 2 because it consists of the relevancy of fact, which is from section 5 to 55. After that, if we try to understand what basically this term evidence means, see, evidence has been derived from the word evident or evidere. So this means that you try to, you try to provide a clear understanding to the court about what all is going on in the particular case. At the same point of time, we try to understand, see, Indian Evidence Act also tries to establish the working structure for the courts from the grassroots level. So it tries to establish that how the courts basically have to work in order to establish the crime or in order to prove something that they want to prove. And at the same point of time, yes, it filters out the truth, that what is the truth, and it tries to provide justice to the people. After that, now moving on to the history of the Indian Evidence Act. Yes, earlier there used to be two towns. First were your British, presidency towns, and the second was once your musafils. So presidency towns were basically governed by your English Evidence Act, and your musafis were governed by your Mohammedan laws or your local laws, and then came into existence your Indian Evidence Act. So for the first time in 1835, the Governor General made an attempt to make an Indian Evidence Act, and it basically existed till 1855. After that, in 1868, Sir Henry Summer Maine, he was basically appointed to make a draft of the Indian Evidence, and he did make it, but that particular Indian Evidence Act was not, it was not passed or it was not enforced. Reason being that he basically had made the Indian Evidence Act according to his own thinking, or looking at the situation, maybe as he belongs to England or some foreign country, he took into consideration the conditions that were prevalent at that particular point of time in the foreign countries. But coming back to India, India did not had that particular conditions at that particular point of time. So that is why that particular Indian Evidence Act did not fit perfectly into the conditions that were prevalent in the India. So that is why again in 1871 an attempt was made by Sir George Stephen. He basically made a draft of Indian Evidence Act, and finally he was the one whose draft was actually finalized. It was approved because it fitted perfectly within the conditions of the India. And after that, it got the the Governor General's assent on 15th March 1872, and it came into force on 1st September 1872. So at the same point of time, Sir George Stephen is also called as the father of the Indian Evidence Act. Now, there are two terms that needs to be taken into consideration. First is the lex fori, and next is your lex loci. So, what is lex fori and lex loci? See, lex fori basically refers to the law of that court where the court is situated, and lex loci basically means the law of the land where the act basically occurred. So, what Indian Evidence Act is, it basically is your lex fori. It basically means the law of the court where the court is situated. So this was given in the case of Bain versus Whitehaven and Furness Junction Railway Company, that Indian Evidence Act is lex fori and not lex loci. Now, moving on to this, I have almost explained you in the beginning itself that evidence has been derived from the word evident or evidere. That means to show clearly, to discover clearly, to prove the things. And basically, the objective of evidence is to, as I've told you, that the main objective of evidence is to facilitate the court to coming onto a judgment, to basically deliver a judgment. So that is the main purpose of the Evidence Act, to basically deliver the truth or to deliver the justice, whatever are the facts that are there, whatever are the things that really happened. To establish all these things, the evidences are important, right? These things I've explained you. Fact, I have explained you totally what all basically is the concept of fact and what does it mean, what are psychological facts, what are physical facts. Now, I'll be just explaining you with an example itself now, that what basically is the basics, just the basics of what are fact and issue, what are relevant facts, all these things we'll be understanding. So this is basically an example that I'll be portraying in front of you, that A shot B with a gun, right? So in this particular case, A is the accused and B is the victim. So A basically is, he will be denying the allegations that are put upon him, and B will be the prosecution, and they will allege that no, A was the only one who basically committed the crime. So they will be alleging two things. Firstly, that A has murdered B, and secondly, A has the intention or had the intention to kill B. So these two things are the main issues in this particular case. They are the principal facts that are there in this particular case. So that is why they are called as fact in issues. So what does fact in issue basically mean? See, fact in issue means that these are the issues where the dispute has arisen, where basically the victim side is claiming that yes, A has murdered B, and secondly, he also had the intention of killing B, right? But on the other hand, the accused side will be claiming that no, my client has not murdered A, or my client did not had the intention to kill A. So these will be the two counter things that will be proved. Now, this thing, see, these cannot be considered to be facts. There is a reason behind that thing. Because if the prosecution is saying this thing, that A has murdered B or A had the intention to murder B, this is a fact for the prosecution. This is the fact for me. This is my mental condition, or this is my understanding. But this is not the same understanding of the defense side. The defense will be saying totally opposite to it, that no, my client is not liable for any offense. My client is innocent. So that is why these are the facts that are in issue right now. So these are the facts and they are in issue. They are in dispute right now. So that is what is the meaning of the term fact in issue. Right. Moving on to the next part, that is your relevant facts. See, now, what are relevant facts? Relevant facts are the happenings that are there either before the happening of the event or maybe after the happening of the event. So like, let's suppose in the present case, A and B had, they did not had good relationship with each other, or maybe A used to irritate B or instigate B unnecessarily. So these are the factors that are relevant to the case, but we are not arguing upon them. What are the main issues or what are the principal issues in the present cases that the prosecution side is contending that A has murdered B, and secondly, that A had the intention of killing B. Right? These facts, that means that these facts that A basically had a bad relationship with B, or maybe A had a fight a day before with B. These are the facts that are not, that are not in dispute. They are just relevant for the purpose to establish this thing. That okay, if they had a fight a day before, it could be a case that they had certain amount of hatred with respect to each other or animosity towards each other. So that can be one factor that may lead to that A has killed B. So these will be considered as your relevant facts. That is, they are the foundation of inferences. Now, obviously, in order to commit that particular crime, certain purpose might have been there, certain motive might have been there. That is, there can be a case that they're not having good relation, or they are having fight with each other a day before. So this can be a motive that I want to take revenge from him, I will kill him. For that, a person now will do a preparation. Obviously, as I've already told you, that your intention or your preparation stage is never ever punishable. Your preparation stage is punishable in certain circumstances that are exceptions, like your dacoity or forgery. All these cases, or forfeiting. In all these cases, these are certain exceptions to the preparation thing. That otherwise, preparation is never ever punishable in the law. So preparation, what will be the preparation? That he went to the market, he bought a gun in order to kill B. And next conduct that he did was that he, after killing B, after killing B, he tried to conceal that gun. He tried to hide that gun so that nobody sees it, that, maybe he has committed that particular crime. So if we consider these three statements that are your evidences over here, that X saw A while A shot B dead. So the first claim is that X basically is now here an eyewitness. That is, he or she, whoever they are, he or she is. Now he or she basically is an eyewitness, and they have witnessed this thing that okay, that A has shot B. So this is a direct evidence. You are directly getting the thing that okay, X has witnessed this thing that A has killed B. So this is a direct evidence. And moving on to the second thing, that Y sold gun to X a day before B was shot dead. Or maybe the third statement, that is Z saw A concealing gun a day before B was shot dead. So in these cases, what will happen? These two statements, second one and the third one, these two are your circumstantial evidence. You cannot directly deduce from these two statements that okay, A has killed B. You cannot directly deduce. Just merely that a person has sold a gun to another person or he has concealed the gun does not mean that he is the one who has killed that person. No. This cannot be something which can be, cannot be said to be concretely correct. At the same point of time, another important thing is that your first statement is a direct evidence that A has basically witnessed this thing, that A has shot B. So this will be your direct evidence, and it is important, and at the same point of time, it is also important that direct evidence should be taken into consideration first, and then we must move on to the circumstantial evidence. Now, when we have your direct evidence, why to directly move on to the circumstantial evidence? Because circumstantial evidence, once they get connected, once they get joined, then only they will be leading us to a certain inference. But when we have a direct evidence claiming this thing that yes, X has seen A shooting B, so this is more important, or this is more, more concrete in nature. Now, there is another term which is called as relevant. Now, as I was explaining you, relevant fact. Fact, we have understood what is fact, right? We have understood what is fact, that it can be a physical fact or it can be a psychological fact. What are physical fact? What are psychological fact? Now, let's understand what this term means, relevant. Now, there are certain areas where relevant and admissibility, they are basically considered synonym to each other. But in reality, they are not synonym to each other. There can be a case that there are certain facts which are relevant but are not admissible in the court of law. Like, for example, if the spouses are having conversation with each other, this is something which is relevant, but it cannot be admitted in the court. Similarly, if a client and an advocate are having some conversation with each other, this does not mean, although it is relevant in the eyes of law, but it cannot be taken into the court, claiming that thing that, see, me and my client had this particular conversation. No. Secondly, there can also be a situation where the facts are admissible, but they are not relevant in the eyes of law. Like, for example, your cross-examination. Your cross-examination are admissible in the court of law, but they are not considered as relevant. But now there has been a change, because now the Apex Court has said that even your cross-examination will be considered to be as admissible in the court of law. It will be considered to be valid in the eyes of law. Okay. So this is the case. At the same point of time, in the case of the relevancy and admissibility, it is essential. So that means that there should be relevancy of the fact, whatever you are producing, they should be relevant in the eyes of law. Now, there is a case of Mahmood Dawood versus Hafsat. I'll just write it again for you all. The name of the case is Mohammed Dawood versus Hafsat. So what was there in this particular case? That let's suppose that there is a custom in India that during the time of the marriage of the daughter, the parent they give dowry to the family of the husband. So let's suppose that if you want to ascertain that how much dowry was given at the time of the marriage of your daughter, right? Or if you want to recover the money that you have given or the ornaments you have given, so in how will you will be proving those things? Obviously you do not have any document over there, and at the same point of time, even if you have a document, so in that particular case, that is not sufficient enough to prove this thing. Any of the party can claim this thing that the like there is if when we try to see in the Dowry Prohibition Act, there is this thing that once the parents of the daughter they are giving the dowry to another to the husband, so in that particular case they have to make a proper list as to what all they are giving, and after at the time of marriage, both the parties, that is the bride and the bridegroom, both of them have to basically sign upon it. But let's suppose that this is not the case, or maybe even it can be a case that the bridegroom or bride deny the same, that these are not my signatures, these are somebody else's signature. So that is why merely documents are not sufficient to prove this thing. At the same point of time, let's suppose you have marriage photographs, or maybe or maybe you have certain evidences like that, but they are not sufficient enough. By looking at the photograph in your marriage does not show and how much dowry was given to you, right? So, but at the same point of time, if these images or if these photographs, they are accompanied by the statement that is given by the father and the daughter, then in that particular case, it can be proved that okay, you can basically recover the ornaments that are given, or maybe the money that is given, right? So basically today what we have we have covered number of things in one lecture today. That is firstly, we have understood that what is the relationship of the Indian Evidence Act with the substantive law and the procedural law, and I've already explained you that Indian Evidence Act is a procedural law, but at the same point of time, it consists of certain sections that also involve your substantive law. Right. Secondly, we understood that what is the meaning of this term fact, what is the meaning of the term fact in issue and relevant facts. Right. Then we have understood the meaning of what does this term relevant means, or what is the difference between the term relevant and admissibility. Right. And at the same point of time, lastly, we have also covered that what is the meaning of evidence, or what is the history of this term evidence. So this is all for this particular lecture. The rest will be continuing in the more lectures, the rest of the things. So thank you everyone for watching the video.